Well, welcome everybody to the second day of the Melbourne Forum 2021. I'm Cheryl Saunders. I'm a convener of the Constitution Transformation Network and a senior technical advisor to International IDEA. So I'm linked to both of our two host institutions for the forum. I'm chairing the first session today, which is on constitutional frameworks for international investment. And my colleague Amanda Katz-Verrill will chair the second, which will deal with subnational engagement in international relations. So let me begin by briefly recapping where we are in our discussions of the interesting issues that we have before the forum this year. The theme of the forum is democracy, constitutions, and dealing with the world. And it's been designed to cover four of the key aspects of the external face of democratic constitutions. There are, of course, other aspects of the external face of democratic constitutions. And I was reminded of this by Akiko Ojima's discussion of the peace clause in the Constitution of Japan on Tuesday, a national commitment to an international policy position embedded in the national constitution. And we can find similar commitments in other constitutions around the region. Now, in the first meeting of the forum on Tuesday, we covered two aspects of the outward-facing constitution. The first was the implications of a greater than usual need for international approval of a new constitution. And in the course of that session, we gained fascinating insights from four polities: Timor-Leste and Bougainville, both in the context of the acquisition of independent statehood, and Japan and Afghanistan, both in the context of post-war reconstruction. We saw how the need for international approval could be both positive and negative, but in either case, we also saw how the need to embed both the sense and the reality of local ownership is obvious. And on that score, we saw positive evidence of how constitutions can bed down effectively over time, reinforcing the importance of implementation. The second aspect of the outward-facing constitution that we covered on Tuesday was the process of treaty making and implementation. Again, we considered four very different cases: Indonesia, South Korea, Bhutan, and Singapore. Between them, they reflected a range of quite different experiences in relation to treaty making, the domestic status of international law and practice, and the general stance of countries in engaging with international law. But despite their differences, a series of similar questions ran through them all, which also will be relevant in today's discussion. Should more open and inclusive democratic practices apply in the context of international relations of any kind? Can they realistically apply, given the dominance of executive governance for practical as well as historical reasons? And how does the de facto power imbalance between states feed into these issues? Might it be helpful for weaker states to have an overt constitutional commitment to transparency before finally committing to international arrangements? Or would it be a hindrance to them? And there was an elephant in the room. How does the changing geopolitical climate affect both the conduct of international relations that have significant domestic effects and the roles that constitutions might play? Now, the first session this afternoon concerns the constitutional framework and practice for international investment. And in this session, we'll focus on three cases: Sri Lanka, Papua New Guinea, and the Philippines. I'll introduce each of the speakers before their presentations, but let me at the outset thank each of them for doing so much to help me understand the issues. This is very much their area of expertise, and I regard myself as a learner. In many ways, this session is the most ambitious of all in this ambitious forum. It deals with any aspect of foreign investment, including, but by no means only, the entry into investment treaties. Foreign investment is covered by its own very particular branch of international law and practice, but it also has the potential to impact significantly on the domestic public interest. That impact may be positive, most obviously through enhanced investment in a state, which is very much sought after, but also potentially through important byproducts such as local employment and the provision of infrastructure. But the impact can also be negative in ways that it may include, for example, implications for the environment, for Indigenous interests, and for the loss of key sovereign attributes, which may even extend to territory. And so again, in this context, we're led to consideration of how democratic decision-making should work in these contexts, and what role, if any, the external face of a constitution has to play. So let me remind you again of the usual format for the Melbourne Forum. Written answers to questions have been prepared by all speakers, and we hope you've had a chance to read them. The speakers will speak briefly to their own case for around 5 minutes or so, and then the forum is open for discussion, and we hope that others in the room will share their own experiences on these critical issues. So let's launch into the first session. Our first presenter is Dr. Delini Pathirana in relation to Sri Lanka. Delini has an LLB and an LLM from the University of Colombo, where she now teaches international investment law. She also has a PhD in international investment law from the China University of Political Science and Law. It was her work that first drew our attention to the importance of this topic, and if you've read her written paper, I'm sure you can see why. So Delini, it's over to you.
Thank you very much. I think am I audible?
Yep, very much so.
Okay, thank you. So greetings to you all. Many thanks for the invitation to be a panelist at the Melbourne Forum 2021. I'm pleased to share my thoughts on the contemporary issues in foreign investment in Sri Lanka, focusing on the interface between the Sri Lanka's constitution and the investment treaty regime. So I found 5 issues worth mentioning at this point, and among them, I believe that 2 issues are crucial in terms of figuring out the interaction between the constitutional law and the investment treaty regime. So to begin with, Sri Lanka is in dire need of attracting foreign investment to address the balance of payment crisis that the country is experiencing right now. However, the situation is tricky because the central bank is running out of net foreign reserves, and in this context, attracting an increased volume of foreign direct investment has become crucial, mainly due to its immediate positive impact on the country's balance of payment. However, the second issue is the increased politicization of foreign investment projects, largely the major infrastructure development projects initiated by the past and the present Sri Lankan governments. The best example in this respect is the much disputed Colombo Port City project, which became controversial during the country's 2015 presidential and parliamentary election campaigns. In fact, political salience of foreign investment is admirable. Unfortunately, however, internal hyper-politicization of foreign investment has a considerable impact on using them as an effective economic tool to achieve the country's national interest. This is because unnecessary politicization allows political figures to exploit the process of foreign investment as an emotive electoral issue to shape their own short-term political agendas detrimental to the country's long-term national development goals. The most recent and important development has been the geopoliticization of foreign investment. And I would like to identify this scenario as the third issue relating to the foreign investment in Sri Lanka as well. To be precise, increased geopolitical concerns were raised relating to the almost all recent investment decisions taken by the Sri Lankan government, of course the executive branch, such as the establishment of the country's first ever special economic zone in the newly built Colombo Port City, and the decision taken to sell 40% of the government-owned shares of the Yugadanavi power plant to an American investor without following the competitive bidding process. So these transactions have been opposed mainly due to their alleged geopolitical impacts and related threats to the country's sovereignty and national security, with opponents framing them as a form of foreign interference in Sri Lanka amid the increased geopolitical competition in the Indian Ocean region among countries such as China, India, and the US. Fourthly, during the recent past, the Sri Lankan judiciary has often been called to make decisions on proposed or ongoing foreign direct investment projects incidental to fundamental right petitions or writ applications brought against them. Most of these fundamental right petitions were brought in the form of public interest litigations, and they have resulted in landmark judgments that upheld the rule of law, safeguarding the country's natural and national resources from the abuse of executive power. Deciding on these fundamental right petitions, the Supreme Court constantly urged the executive to exercise its power in trust for the public benefit. However, several overlooked aspects are involved in the emergent trends towards the challenging foreign investment projects as fundamental right violations or by way of writ applications. One of such aspects is the possibility of these domestic proceedings giving rise to investment treaty arbitration against Sri Lanka if the procedures adopted and the resulting judgment in this lawsuit contravene the country's international investment obligation undertaken by entering into bilateral investment treaties nearly with 30 countries. Broadly speaking, bilateral investment treaties are international legal instruments aimed at protecting foreign investors and their cross-border capital investment from undue interference from the countries hosting them. These treaties covers legislative and executive measures of the host states as well as the administration of justice in the host state courts. Finally, and more importantly, Article 157 of the Constitution of Sri Lanka provides a framework for Sri Lanka's bilateral investment treaties. Accordingly, a bilateral investment treaty can be approved under Article 157 of the Constitution by way of a resolution passed by the special majority of the Parliament, considering a given treaty is essential for the development of the national economy. As a result, the provisions of such approved bilateral investment treaties acquire the force of law in Sri Lanka. Remarkably, Article 157 expressly prohibits making or enacting written laws or taking executive or administrative actions in violation of the provisions of such approved bids, except for the interest of national security. Accordingly, Article 157 allows entrenching Sri Lanka's international investment obligation into the domestic legal system, making them justiciable before national courts. At the same time, this article imposes a constitutional restriction on lawmaking and public authorities, preventing them from adopting measures in violation of treaty provisions of these approved bilateral investment treaties. Thus, the Article 157 establishes a unique constitutional framework under Sri Lanka's bilateral investment treaties. However, its legal consequences have not been sufficiently explored both at the national and international levels. So these are the 5 main points that I wanted to highlight at this point, and I would be happy to elaborate on them during the discussions. Thank you.
Thank you very much, Delaney. That was fabulous, and I can't believe you managed to squash so much interesting information into such a short period of time, and also in your written answers. When Delaney and I were talking about this topic a week or so ago, she said to me, "Oh, Sri Lanka's at the forefront of this question of international investment and its interface with domestic politics, and you can see why." And including the involvement of the courts, which is also extremely interesting and probably made more possible by the potential for public interest litigation. So that was very interesting. The part at the end about Article 157 of the Sri Lankan Constitution is also really fascinating. And hopefully we can come back to that in question time. So thank you very much again.
Thank you.
Now, our second presenter is Christopher Karai, in relation to Papua New Guinea. Christopher has an LLB, a Bachelor of Business and Management, and a Bachelor of Economics from the University of Papua New Guinea. He practices law and he's the principal of Morgan's Lawyers. He's the author of Administrative Law and Judicial Review in Papua New Guinea, amongst other publications. And he spoke briefly about treaty making in Papua New Guinea on Tuesday in response to a question by Tony Regan as a teaser for his presentation today. So over to you, Christopher.
Thank you, Cheryl, and thank you, everyone. Greetings from Papua New Guinea to you all. This is my first time to participate in this prestigious forum, and I'm very pleased to present briefly what the investment environment in Papua New Guinea is, and for our discussion purposes. Firstly, the Constitution of Papua New Guinea does not specifically provide for international investment and how that can be implemented in Papua New Guinea. However, we have a number of international investments in the country, and those are in the areas of forestry, minerals, oil and gas, amongst others. The main international investment that we attract in the country is in relation to mining and petroleum resources. And those are governed by ordinary laws, legislation passed by Parliament. We call it the Oil and Gas Act and Mining Act. And they are various specific project related agreements, and also those at times passed by Parliament to give effect to the agreement, as well as to protect international investments. The basic procedure or process that's being followed by the PNG government and international developers, especially in the areas of mining and petroleum, is that the PNG government signs a framework agreement with the international developers. From then on, the landowners, who are the very important stakeholders in the process, they participate in terms of deriving the benefits, the royal monetary and also non-monetary benefits. There are various issues in regard to the benefit sharing with the landowners. And as many of you would know, Papua New Guinea, land in Papua New Guinea is mostly owned by the customary landowners, 90% of which is owned by customary landowners, and only 3% is owned by the state. So most of the resources, especially mining, minerals, and oil and gas, are found on customary land. So that makes the customary landowners more or very significant stakeholders in the process. So as our friend James Tanis discussed or presented yesterday regarding the the Bougainville mining, that is one of the issues that was raised at that time. The issue was related to the benefits and also the destruction of the environment, and that's how the civil unrest or civil war has occurred, and the way things are now has been presented yesterday. Also, we have a PNG LNG project, which is also on stream now, and it has been developed by ExxonMobil. But the production has occurred few years ago, and the payment for royalty payments are yet to be paid to the landowners. And the issue has been the proper identification of landowners. And that has been the issue that has been pending for some time now. With regard to, and further to that, we also have various court proceedings in the courts that is related to infighting between the landowners themselves. So all these issues compound or give rise to the issue of not the benefits not reaching the people on a timely basis. And coming back to the protection of the landowners, the Constitution also, our Constitution also recognizes customary landowners and also what the compensation or kind of compensation they should receive. The details of which is not provided for, but their rights to claim compensation for any development that takes place on their land is provided for by the Constitution under Section 53 of the Constitution that protects them from deprivation of their land. So as I've said, since there is a vacuum or the Constitution is silent on what kind of foreign investment that should reach or that should arrive in our shores, the ordinary laws provide for that. And that I've also stated that in my presentation just a while ago. And in terms of the governance and transparency and accountability, these issues have been pending since the country gained its independence, and also the number of mechanisms have been put in place to address these issues. One of which is to gauge prior and informed consent. At most times, and also in practice, that is almost impossible to obtain because of the issue of the landowners being so isolated, and also most of them are illiterate. So what the government and the developers do is that they try as much as possible to engage them by way of face-to-face and also print media. And we have also anti-money laundering and anti-corruption, and counter-terrorism act, which addresses some of those issues which related to international financing as well. So that is, in the nutshell, what the investment environment that we have in this country. And I am willing to discuss further, or even for the purposes of our discussion in this forum. So thank you very much. That's a brief outline of what we have in this country. Thank you so much, Christopher. You've added so much to the discussion. I mean, one, quite apart from anything else, by bringing the Panguna mine into it, you've shown some of the real significance that international investment can have domestically, depending upon how it's carried out. And that's a very important insight, I think, to bear in mind. But also your discussion of the distribution of royalties and the way in which free, prior and informed consent works. It's a new element to the discussion. It's obviously very important also for the way in which these investment decisions are made. And it may have some implications for the next session on subnational government that we'll come to after the break. So that was really great. And I want to come back to you later on aspects of the Constitution, but we'll worry about that later on. So let's move on to invite our third presenter to speak. Our third presenter is Alim Guiapal, who's speaking about the Philippines.
Alim specializes in Philippine investment strategy and stakeholder management. He's a Fulbright Hubert J. Humphrey Fellow in Economic Development from Michigan State. He's led co-investment and economic missions in the United States, Asia, and the Middle East. He's presently Group Manager of the Promotions and Public Relations of the Philippines Economic Zone Authority. So it's very hard to imagine a better person to present the case of the Philippines. And I should say we're very grateful to Benny Bakani for making the connection. So Alim, over to you.
Thank you very much, Cheryl. And I also would like to thank my colleague, Delaney and Christopher, for providing the earlier discussion on the impact of the Constitution to different investments in the different parts of the world. As mentioned by Cheryl, we've been doing a lot of work in terms of economic mission during the pandemic, and I'll be happy to share to you the discussion on how Constitution provides specific procedures for approval or protection of international investment in the Philippines. And I actually spent a month deciphering the issue on the impact of constitutional to domestic governance. And I'm very glad for this opportunity, both to Dean Bakani and to Cheryl, Charmaine, and the rest of the organizers of this forum. Let me just walk you through, I would just like to walk you through the 4 key areas that, based on the assessment of the Philippine investment, plays a very crucial role in terms of the impact that it gives to domestic governance.
Can you get it up okay, Alim? We're trying to do share screen, everybody.
Yeah. You can see my screen now?
No, no, we can't.
Have you pressed share screen down the bottom, Aline, on your
Yeah.
Zoom itself?
Yeah, that's it. I think I'm getting to it. Okay, here. Good. Are we good?
It's coming, it's coming, Alim.
Good one.
We're done.
Okay.
Brilliant, thank you.
Yeah, so I would like to walk you through the 4 key areas that gives, in terms of, of the analysis on how the Constitution presently works in the Philippines to international investment. This is how we see are the essential factor that affects domestic governance. Number 1 key area is of course, the Philippine Constitution. And what we see as the value addition of this is the guarantee, both to national interests of the Philippines, as well as to the ratification of the international agreement that we enter into. Second is that the ratification and the role we played in the international agreements had a crucial role in terms of building up the credibility of the country. And the special laws and the ordinary laws, they are the ones that articulate the policies and the implementing mechanism to support both the guarantee being provided by the Constitution and the credibility that being built up over time by the Philippine government. And as a result of that, the final key area brought by transparency and public accountability is both exemplified by job generation and investment. In terms of the impact of investment decisions, domestic governance, and constitutional provisions, we see the value of special laws that are being generated through the provision of income tax holiday, the provision of the special corporate income tax being driven through Philippine investment. This also comes along with other incentives, such as what you see in the figures below, the employment of foreign nationals, the special visa that being provided to foreign investors, and the long-term land lease being provided, which in most cases under the Foreign Investment Act is geared toward 75 years. Now, with reference to the articulation of the policies that we mentioned earlier, we see the value of the Constitution as a guarantee remain as it is, but without the articulation of the special laws, it doesn't really give any support in terms of generating investment. So as we discuss the articulation of policies to supplement constitutional guarantee, these are the things that we've been currently working and currently implementing. Basic rights of investors are guaranteed. As an effect of that, as a result of the ratification of some of the agreements that we that is being ratified by the Philippine Congress, which requires 2/3 of vote. GSP Plus is granted to the Philippines. That also includes zero tariff on 6,274 products destined for Europe with 40% local content. We also see, as an effect of the articulation of the domestic policies, the stronger interagency support and collaboration with other investment promotion agencies, not only within the Philippines, but also with our neighbors in the East Asia and the Pacific. The business facilitation with the whole of government approach. In one of my discussions with Cheryl, we made mention that the platform for debates and consultation of investment policies in the Philippines plays a very crucial role. And as a result of that, the progression of a business-friendly environment and policies to Philippine investors ensure or provide the guarantee being articulated through the Constitution by means of the special laws that we have been providing over the years. And as a result, in one investment agency alone, we have generated around 1.6 million directly employed workers. Over time, we also created or generated around $40.6 billion in terms of export. That contributes to the overall Philippine export of commodities and goods. And in terms of the second key factor that we mentioned about building the credibility, we see an interrelation of the experiences between Sri Lanka and Papua New Guinea. In the Philippines, we are addressing this through the laws on the ease of doing business, making sure that we fast-track the decision-making process, not to dilly-dally transactions between the Philippines and our counterpart abroad. Same true with Papua New Guinea. We have common scenario of the freedom of information, making sure that there is a right of information being accommodated through the public. And Sri Lanka also provide a very strong case about the regulatory framework and making sure that the environmental impact are being ensured in the decision-making process of investment generated through mining. We build the brand, which we say more than the Constitution itself. It's important to have the credibility, and that credibility can be supported by special laws other than the constitutional guarantees. Over time, some of the institutions in the Philippines created the report of being a one-stop shop and facilitating the world requirement of the ease of doing business. At the same time, making sure that we build the confidence, not just of the domestic governance, but also the issue of the interrelation between the Philippines and other countries, local and abroad. So that completes the 5 minutes presentation. I hope we managed to give a summary on it's actually supposed to be an hour presentation, normally what we do, but thank you, Cheryl, for allowing us to give the 5 minutes. We appreciate it. So this is how to reach us.
Thank you, Aleem. Thank you, Aleem, for putting 60 minutes into 5. We're extremely appreciative of that. And I love that little circular chart of yours. If we can save your slides for our website, that would be great. And thank you also for the insights into the Philippines. I mean, that last slide of yours where you did the comparison with the other two countries involved in this session was very interesting because it had appeared to me that the Philippines was taking a very proactive and organized approach to international investment. And that was what struck me first about your answers to the questions when I first read them. I thought, here's an enthusiast for international investment who also sees how important efficiency and managing corruption and so on are, but who also draws attention to the range of benefits that can come from international investment. And I think that's very important for our discussions today. If we assume, as each of our presenters have, and I'm sure everybody in the room does, that international investment is necessary and brings benefits, how can we maximize those benefits? What stance does a domestic government have on that? What stance can it have on that? in an unequal world? And how does democracy and constitutionalism play into all of this, if at all? So that was a tour de force. Aleem, thank you so much. Now, we're up to discussion time. Let me, on everybody's behalf, thank all three of our presenters for setting us off on this theme so splendidly. The topic is now open for discussion. Of course, I very much hope you'll all pursue aspects of those presentations with questions and comments and comparisons. There's a lot to be said. But I hope that everyone will also offer insights from their own jurisdictions to the extent that these issues have resonance for you at home. In terms of format, those of you who are in the group of presenters with access to the Zoom functions, please use the hands up function or just wave in the air. And those in the audience, if you want to put questions into the Q&A function, I'll put them to the presenters. So who would like to start?
Mariam has a hand up, Cheryl.
Thank you. Who has? I can't actually.
Mariam.
Oh, Mariam, please do come in. I was hoping that you were around and could say something about the Maldives.
Yes, thank you, Cheryl. I just was also very fascinated by Delaney's paper, which is, I would say, a very sophisticated legal system in comparison to Maldives' system, because, of course, they have the judiciary oversight function as well as the international treaty arbitration function. Although in the case of the Maldives, we do have international arbitration act come in much later. I think once we reach that stage, it becomes a little bit late for the damage that has been done. Right? Because it's very hard for countries like the Maldives and Sri Lanka that have placed in this geopolitical hotspot, whereby it's very easy for us to say, yes, give us the financing, the developmental financing for bridges and this project and that project and so on. Thank God we don't have offers from multinational corporations like Exxon that Aleem was talking about. But nonetheless, we do have push and pull factors from major players like China and India, who are always running after some investment opportunity for them for a return on their investment dollar. And for us small countries, it's very, very difficult to stay independent and sovereign. The question that I wanted to ask Aleem, Aleem's presentation was very, very much based on attracting foreign investment. And how do you actually, separate the wheat from the chaff, for example, the good investments from bad investments? How do you, say for yourself, here we are, we've got a really good investment here. We're going to make use of this, bring the benefits to our people, at the same time, be accountable to the people. In the Maldives, for example, we've had a proposal that's been, that's running a little bit of a controversy at the moment, and people are just running up and down, show us the details, and whereas the executive is saying, we're not able to show, unlike the 157 provision in the Sri Lankan constitution, we don't have that. We have a constitution where the executive has tremendous powers, tremendous powers to create foreign policy, tremendous powers to create a defense policy, security policy. So executive is putting one hand on the agreement and saying, no, there is nothing that is threatening national security. Yet at the same time, people are questioning what are the benefits of this developmental proposal. So Aleem, I'd be very happy if you could show us the way in how to find out what is a good project as opposed to something that is questioned by the public. Thank you.
Okay, we might just collect a few questions and then come back to the speakers, and it may be Marianne, that some of the other speakers might have comments on that as well. But thank you very much for your question. That's great. Dinesha, would you like to come in too?
Thanks, Cheryl. And let me begin by thanking Dilini, Alim, and Christopher for really sort of clarifying what's happening on the ground. That was extremely useful. So mine is more a comment than a question and might be slightly different to the direction Maria was going in. So listening to all three of you, I realized that we are talking about three different areas. We are talking about politics, both at the national level and at the regional level, but also the international level. We are talking about the very sort of internal logic of the law as it operates, how it moves across the international and the domestic. And implicit in that conversation is a recognition of the need to have a normative consideration as well, because there is an idea as to how economic policy should be decided, what informed consent means, how custom should apply, so on and so forth. And that's, I suppose, the most complicated level at which we could have this conversation. And again, listening to the three of you, I was sort of pushed to see that there is a very clear flipping effect here. When you're at the international level, particularly states seem to be reacting to international law in a particular way. When it comes to international law and economics, there's a particular dispensation. And at the first and second sessions, we were reminded that when it comes to human rights law, and perhaps one could add humanitarian law and international criminal law, there seems to be a very different reaction. You bring that to the national level, and again, there seems to be a flip in how people respond, and in comes civil society, and in comes local actors. You take it to the local, the sort of the regional or the subnational level, and it seems to flip again. So at each level, the emphasis we place on economics and economic policy, foreign investment, and if you contrast that with human rights, seems to vary. And the Constitution sits in the middle of all of these tensions. And it seems, and I'm sort of thinking this through as I share this comment with you, historically, constitutions were assumed to deal with civil and political rights vis-a-vis the governments and the states. And exceptionally today, we recognize that, okay, constitutions may say something about economic, social rights. But we are far behind dealing with the kind of economic policies that the three of you are talking about. So the question for me is, can constitutions take on the challenge of navigating these economic policies? Then the other question is, does it have a choice? Because the story that the three of you are telling us is, it doesn't really have a choice. And because it's being done without the sort of clarity, there seem to be unnecessary tensions that are being developed. Your point, Dilini, about the judiciary speaking to a national audience and thereby perhaps placing the state in a difficult situation vis-a-vis international actors highlights that very clearly. So the challenge for those in the constitutional sphere is really to take on this challenge of using a system that has been developed for a very limited scenario to now adapt to a very rapidly changing regional and international scenario. So thank you very much for further clarifying these challenges. Thanks.
So thank you for that question, Dinesha, which I'm sort of controlling myself from entering into this this discussion, but we might pursue it a bit more as we go through the rest of this theme. I think there's been so much in those two questions that we might go to our panelists now, and Arturo, then we'll come back to you in a moment if that's okay. Just before I go, I'll ask you first, Alim, but I'll ask you if you want to say anything about either of those questions, and then I'll go to the other panelists as well, Dilini and Christopher, because there's a lot in I think, both questions, but certainly in what Dinesha originally described as a comment, but which turned into a really interesting question. Just before I go to Aleem, Anna Jedget's just reminded us in the chat to ask everybody to turn on their videos if they can, and if that's not going to blow the internet. So if you can do that, that would be great. So Aleem, can I come over to you now?
Yeah, thank you, Cheryl, and thank you to Mariam and the Center for the questions. I would like to, I think I pick up 3 questions. One from Cheryl earlier, she made mention about how to maximize the benefits. If you see the pie that I presented earlier, you know, the Constitution and the special laws that support the Constitution are good in paper. But in terms of making it work, it requires the credibility of the country. It requires also the confidence working with international partners as we ratify the treaties that are open also for public debate. So the way to maximize is to be very specific, is to make sure that we implement what you write. We implement the guarantees of the Constitution in terms of protecting national interests, in terms of working or expanding or building the confidence with international partners. I go to the question of Mariam. We are, the one that I presented are more on the good side of how do we do business, but we are 100 million nationals in this country, and there are also issues that we debate a lot. If you have read the paper that I wrote, I made mention about some of the challenges, like the building up again of the mining and the other areas of investment that have been open to public debate. But to answer the question on how do we assess the projects, that where comes the role of the executive branch. Say, for instance, institutions like ourselves, like the Philippine Economic Zone Authority, the Board of Investment, the Ministry of Trade and Industry. We make sure that we give teeth to the provision of the law, and we also provide a really good managing body. In one of the report of the UNCTAD, one of the success factor in building the economic zones worldwide is a very good managing body, a managing body that builds the confidence of people who put up their money. And also addressing the issue raised by the senator earlier about the respect to cultures, the respect to customs. We make sure that is being guaranteed by the Constitution, especially in the Philippines. But we also address some of these issues by supporting special laws, like the issue of the autonomous government, the issue of inclusive economic policy. We have around 10 million Muslim Filipinos in this country, and we make sure that we also address some of their concern. We always believe that no national development or no national interest would move forward unless these minority issues are concerned. So we had special laws to this effect. We have Islamic banking law that is being that is passed in the Congress 2 years ago. We also have the Bangsamoro Organic Law that addressed the halal and the specific requirements of the local government in the autonomous region. Thank you, Cheryl.
Thank you very much. Who would like to come in next? Delini, would you like to?
Yes. Thank you very much for the questions. And I would find a way to link my answers to both questions together. So with respect to the first question, whether how you can ensure the public benefit of these foreign investment projects, I would like to bring about some theoretical perspectives, because there are the economic theories on foreign investment. One is about the classic theory, which says that the foreign investments are entirely benefit for the host state country, the host state developing country. So if you want to get the development, you would encourage foreign investment, and then you have to facilitate them and protect foreign investors' private interests, because the more you get foreign investment, the more you get development. So that was the classic theory. And the second theory is about the dependency theory, which is totally opposite side of the classic theory, where you say that you should not encourage foreign investment because it may give some positive impact, but at the end of the day, you will be dependent on the central economies of the world, because these policies, all the investment companies, multinational companies operating in your territory, they are steered, they are looking forward to maximize the benefit of the shareholders in the countries where they have headquarters. So the ultimate benefit is going to these multinational companies and their home economies in the Western world, not for the general public of the countries that host in foreign investment. And there is another view which find some balance between these two extreme theories, which is known as the middle path. It depends upon the impact of foreign investment in a given economy. It's depend upon how you regulate them, because you have to decide if it is beneficial. Of course, you have to provide, facilitate foreign investment, but at the same time, you have to have some sort of a regulation to ensure that, because the foreign investment are not going to automatically provide you with the positive impacts. In order to ensure that, you should have some sort of a regulation at the domestic level to ensure to maximize the benefits of foreign investment while minimizing the negative impact. So looking at these, I think for a country, it is very important first to recognize what is their policy toward foreign investment. Are they considered as the classic theory, dependence theory, or the middle path? So if country have a clear policy on their approach toward the foreign investment, then only country can decide a national policy, and then they can create the legal regime according to the achievement of this policy goal. So it is very tricky question to answer that, like how you can decide. But it depends upon your attitude toward foreign investment. Of course, if you believe that it is entirely beneficial for the country, of course, you can liberalize your economies. You can provide foreign investors with increased market access and give them the maximum protection under international law. But at the end of the day, your regulatory power over foreign investment will be minimized. But if you want to, if you don't want to engage in this economic globalization process, then you can deviate from and you can discourage foreign investors. You can have very restricted policy for their entry, and you can close your market for these foreign investors, and you can have maximum control under domestic law towards foreign investment. So it's very important at the very beginning, countries have a clear-cut idea about what is your approach toward investment policy. Do you want it or do you don't want it? And if you want it, how you find a balance between the promotion, liberalization of foreign investment and the right to regulate of the host state in the public interest? I think that is the most difficult and fundamental question. At the very beginning, a country should decide, and then only you have to choose foreign investment projects. What happened in Sri Lanka was most of these disputed Chinese investment projects was not choose wisely. They were driven by certain political motivations rather than economic rationales. And the problem is, I think the Sri Lanka doesn't have a clear-cut national policy on foreign investment. Each government has separate or disconnected ideas about how you promote, what kind of foreign investment you want. So the lack of national policies in developing countries is one of the biggest problem towards their approach toward foreign investment. The first one is developing countries. First, you should be very clear about what is your approach toward foreign investment, and then you have to have national policies, and then you should design your legal regime on inward foreign investment accordingly, and then only you have to move forward with the foreign investment, because it's always a double-edged sword. You can get benefit if you really regulate and wisely choose projects. You can be lose, like what happened in Sri Lanka, if you did not choose your projects wisely and not regulate them. So if I link with this question with the Dinesh's comment, yes, it's very difficult for countries to make a choice between these approaches, because throughout the history of foreign investment, you would see that the developing countries didn't have a choice. Right? So if you look at their project for creating new international economic order, they wanted to have much control over the foreign investment. They wanted to control and regulate foreign investment activities through the domestic law. But even though they were advocating those policies at the international level, once they come to the domestic level, they wanted to adopt more favorable approaches toward foreign investment, and they agreed to bilateral investment treaties, which include standard which is totally different from what they were requiring at the international level. At the international level, they don't want to give the maximum protection under international law, but once it comes to the domestic level, and once they entered into bilateral investment treaties, they entered into treaties which totally different from what they have required at the international level. So it's very difficult choice for developing countries to have their own approach, deciding their own approach toward foreign investment, because under the neoliberal agenda, always bilateral investment treaties and foreign investment was promoted by the Western countries, saying that you should open, liberalize your economies for the foreign capital. So then always as a structural reform, they advocated signing bilateral investment treaties, which allows foreign investors to recourse international arbitration, because they said that the more you protect foreign investors and their rights under the domestic code, under the international law, the more you get foreign investment. But there is a question: what is the link between the inflow of foreign investment and your bilateral investment treaties? Because some countries like Brazil, they don't have ratified bilateral investment treaties, but still they receive an increased amount of foreign investment. So even in Sri Lanka, you assume that by signing bilateral investment treaties, you will attract foreign investment. But I think most of the countries should have very clear research on this. What is the link between the sign of bilateral investment treaties, which allows the foreign investors to challenge you before international arbitration courts, or the international, sorry, not the courts, international arbitration tribunals, and how it impacts or increase the foreign investment inflows towards the country. And my final point is, again, it's very difficult for you to decide on these arbitration methods, because once the most Western countries, they were exporting capital, they promoted the ISDS mechanism, or they promoted foreign investors to allow challenge host economies in international arbitration. Now the situation has changed. Now they have a dual capacity, dual role as well capital importers as well as capital exporters as well. Chinese companies now invested in these economies, and now they're using this system, the bilateral investment treaties and the ISDS mechanism, to challenge those Western governments. Now they are coming up with a lot of allegations, and now they find fault with the ISDS mechanism, which has been promoted by these countries in a given point of history. Now they wanted to have safeguard their regulatory space to regulate foreign investment for the public interest benefit. So in these questions, it's very difficult for national constitution to regulate these issues, because it's very complicated, and always your approaches depend upon what is your role in the context of foreign investment, whether you're a capital importer or a capital exporter. So it's very difficult.
Thank you, Dalini. I think you've just added a new item to the agenda of constitution building, but we'll come back to some of those issues in a moment. Christopher, do you want to come in on the answer to these first two questions, and then I'll open it up to Arturo and others.
Yes, Cyril, thank you very much. Thank you for the two questions. I think I'll answer it very short, in a very brief form. What in terms of what we have in this country, we, as I've presented earlier, we don't have a legal, the constitutional framework as to how the investment, the foreign investment, should be accepted into our country. Now, that doesn't mean that we don't allow international investments to come into our country. We do have the ordinary laws that provide for, and as our panel members have already said, the mechanism or the policy framework in which we attract international international investment is really based on the politics of the day. Now, whichever the government that's in power has its own policies and policy aims to be implemented. So in our case, those are the reasons why the international investment is really confined to agreements, not so much on the legal framework, because legal framework only regulates what the mining or the petroleum or oil and gas areas should do and should not do. But in terms of maximizing the benefits, those are issues that is being negotiated by the government of the day, that's the executive government, and implemented by both parties. And as I've said, the landowners in that respect is very important in terms of what sort of benefits they receive. On the issue of what sort of mechanisms that we have in this country for attracting international investment, well, as Alim has said, we also have tax holidays. Usually that is decided by the executive government, as I've said already, but in practice that's 10 years investment, tax holidays given to attract international investments. And again, the benefits are now left to the negotiation table, and that's being decided and executed there and then. So that's what we have in this country. Thank you.
Thank you very much, Christopher. Okay, let's open up to another round. We've got a question in the chat, but Arturo, you've been waiting long and patiently, so it's over to you.
Yeah, thanks, Cheryl. And it's been a great conversation. This one is very informing, and yeah, it's been exciting for me to hear. My question goes goes more for accountability. Like, it seems more that Sri Lanka and also Aline was saying, like, they're happily to engage with the international investment area. So they need to have a clear cut. But like, yes, international investment law gives you it gives you a framework which you cannot go out. It's like either you accept arbitration or you do. But the thing is not to see it as gloomy, but like I was saying, like, are there like checks and balances in places? Because if you want to negotiate, open yourselves up, you usually do a model bid, like Brazil did and other ones. And that was just right now, in a sense, we developed the Guatemalan one, but it was actually in response to arbitration. Like, we developed a bit in a way to safeguard indigenous peoples, and also an extension of courts. How long can courts actually take on resolving investment issues, timeframes, and those? So accountability over that, what do you think it would be? Like, it would see, like, first of all, like in the US, the Senate delivers guidelines on how you can like negotiate and over this. But other countries, well, like Guatemala, like mine, it's just like, we just winged it. Literally on our experience with international arbitration, which hasn't been good at all. And so that's why we've been trying to protect ourselves, including all these special clauses that gives special tiny little details and everything, and to limit the scope of arbitration. But we also find it interesting, and also policy level, that international bids like this are not as bad, because and I want to ask you to reflect on this, and maybe you can help. Like, what do you think? Because most of our bids now with Europe or the US do bring strong labor ILO conventions protection. So they said, like, CAFTA brings like 10 ILO treaties. Either you respect them or you get a interstate suit. Guatemala was the first one to get an interstate suit on labor matters. Now we're getting also strong suit on the CAFTA on environmental issues. So it's state against state, and it's not actually a commercial or investment, but it's actually under these big frameworks of general governance. It seemed that now investment is also moving to provide and bring human rights issues, like in Guatemala. We've inserted strong human rights issues. We inserted like what is Ruggie principles, also anti-corruption. So it's also like a supranational framework that actually we embedded in place that actually help also ourselves for the governments next to not like step over. So like we cannot do it ourselves. So a big kafta, sometimes Big Brother US keeps us in order. So, and sometimes like, yes, you can ask, yes, sovereignty, but I'm sorry, like I love water, but I'm happy for us to get sued for the US by not abiding like 8 ILO levels, 8 ILO treaties, conventions. So I just wanted to hear your prospects on that, and thanks for the conversation, actually.
Thanks, Arturo. Now, Tom, can I bring you in on this? Tom Daly?
Sure. Yeah. What an interesting discussion. I mean, you could see I put my hand up and then I put my hand down and then I put my hand up again. I was really waiting to leave space for others. But I mean, this is fascinating for a constitutional lawyer to listen to, because you can see already the gap in sort of perspective between constitutional lawyers and investment lawyers. And what's really interesting to me is, and I don't want to go on for too long, but sort of moving on from what Dinesha said and what Arturo said, you know, some of our toolkit for putting constraints and sort of oversight on, you know, investment, especially big investment projects, are things like human rights, which you can only sort of nibble at the edges, you know, if something goes wrong. And I think a lot of this brings us back to the very fundamentals of sort of our philosophy of the state and of the constitution and of the executive. You know, we expect the government of the day to be the sort of the most active part of our sovereignty in a sense. They're our mediator with the outside. They're also supposed to be our protector against predatory practice from the outside. But what we see happening in some of the case studies here, or if we talk about a lot of the different sort of, you know, countries in the region, is the government almost acts more like a fixer for the outside, bypassing the public and achieving outcomes that don't have hardwired in the public interest. And what I'm wondering is, you know, if we think about that, you know, that's a hard question, because, you know, it comes back to, as I say, very fundamental questions of the Constitution can act as a power map. You know, where does power reside? Where is power visible? Or it can actually obscure where does power reside and where is power visible. And I think sometimes, often with our constitutional structures, you know, it's that obscuring that's happening, because you get this sort of picture as though there's enough constraint and there is a clear process, and you have a pretty bare process for the executive to actually legitimize what's happening. But I wonder, you know, what was really interesting to me in listening, and I'll start wrapping it up, being Irish, I always go on for too long. But, you know, rather than just relying on human rights, for example, or good governance principles, you know, do we need to pay more attention to the interaction among freedom of information, anti-corruption review? Does it have to be calibrated? And should we have variable intensity of scrutiny depending on the scale of investment, the territorial sort of scale of investment, who are the communities affected, the identity of the investors, you know, because we have the power of multinationals on the one side, we have big geopolitical actors like China on the other side. And I think, you know, what I'm hearing here is that the formal legal frameworks can look good, say the right things, but not achieve actually a whole lot in practice. And do we almost have to go back to the basic first starting questions of what are the structures that need to be in place? Do they need to be in the Constitution, for example, if we were to be writing the Constitution today or amending the Constitution, to actually make the power that's being exerted on the state, investment power and geopolitical power, more visible and more subject to control?
Thank you so much, Tom. Lucky panelists, I'm going to come to you for reactions in a moment. And then I'm going to go to Jonathan, who's put a very interesting series of questions in the chat, but we might deal with the questions from Arturo and Tom first. But can I just say two things about Tom's question before I throw it over to you? I think one of the ideas that he's just put on the table is the idea of a package that has constitutions in it, but that might also have a whole lot of other things in it, including freedom of information laws and so on, and including Delaney's suggestion from the earlier round of questions that, first of all, you need to make up your mind. What is your stance on international investment, which I thought was a very sort of a useful, also moving part to put on the table. But my other quick comment on Tom is he gave us three alternatives of the role the government might be playing. I can't remember what the first two were, but the one he sort of landed on third was fixer. What if the government's a fixer with the international community or entity? And of course, that's a possibility, but I also wondered whether there's another one, which may be one of Tom's first two, which is the government actually wants to stick up for the public interest, but is finding it hard because it's such a weak player. In that situation, is it helpful to say, look, I'd love to, but gosh, I can't without consulting with the traditional owners or whatever the situation might be. And look, gosh, it's in the Constitution. I mean, it's not like it's in an ordinary law or just in a government policy. So, of course, that's very much a domestic constitutional lawyer's response. And I agree that we're bringing together two different disciplines here, but it's just another sort of possibility that I'd like to raise. Okay, who would like to come in on this? Aline, why don't you start again?
Thank you, Cheryl. Thank you, Arturo and Tom, for the questions. I would like to approach the question based on what Delaney mentioned earlier about the clarity, the clarity of what is written in the Constitution, how they implement it. But in term by practice, I've been engaged in the investment promotion for more than 10 years. And when it comes to clarity, there's a crucial role being played by the implementing agencies. So the executive branch of the government who ratify the Constitution or the treaties, they have a huge role to play. And to answer Arturo's question, from the start, with the Philippine Economic Zone Authority, we are clear about two things. There are two things that are non-negotiable in the laws of the Philippines. Number one is the domestic law on labor, and number two is the domestic law on environmental protection. And why it is crucial, why the role of the implementing agencies are crucial, because we can cancel the registration of these investors. Our job doesn't stop by inviting them and putting them in place in the country. But if you don't follow, if you violate the domestic labor code and the domestic environmental law, any implementing agency for that matter can cancel your registration to operate or do business. So it is important the implementing mechanism bodies plays a very crucial role. Now, second, on what Tom mentioned about how domestic governors are being managed, about the issue about the corruption. Now, again, going back to the implementing mechanisms, the court has a role to play. In the Philippines, we've been challenged also. If you read page 6 of my paper, there's an issue about the legal anti-corruption framework in the Philippines is quite complicated, and it is being poorly enforced, and also stakeholders report with regard to the regulatory enforcement in the Philippines is generally weak. So these kind of issues signal us, implementing agencies, to make sure that when it comes to decision-making process, it should not be centered to one person, one authority, or one governing body. It has to be a shared decision-making process. So one of the best practices that we had at the Philippine Economic Zone Authority, which we presented earlier, is that it's not centered to one body. We have a board, and that is controlled, and that is being seated by different ministers from different agencies. So by saying that, any implementing agency for that matter should be very strict into the role that it plays vis-a-vis the constitutional guarantee, the enforcement of the domestic laws, and making sure that we build this kind of credibility and brand over the international partners. So They cannot just come in and violate our domestic laws, culture, for instance, and disruption to some of the rights of the indigenous communities or indigenous people. Thank you, Cheryl.
Thanks, Alim. Christopher, do you want to come in on this? And then I'll go to Delaney.
Yes, thank you, Cheryl. I'll approach a question Carlos asked first. With regard to arbitration, international arbitration in our courts. In my experience in this country, we have the agreements that our government enters have a clause that says that any dispute has to be brought to the international arbitration. And that is a very interesting area because we haven't gone to that extent as yet since the agreements have been entered into. The one that was arbitrated in the international arbitration happened, I think, a year or two ago, but it got dissolved there. The parties have came back and agreed, and they discontinued the matter. That's what I understand. But one of the aspects that I've come to notice with the international investments in the country, especially the extractive industries, is that they don't trust our courts. And whenever there's an agreement entered, they want if there's any dispute, that has to be arbitrated in the international arbitration, not in our courts. So our people and the stakeholders in our country has always been asking, why should international or multilateral companies should not resolve the issues in our courts? And that has been an ongoing debate. So I'll leave it at that. That's Carlos, your issue, your question. Coming back to Tom's statement and offers the questions. Well, our constitution provides for the freedom of information, and also human rights issues are also provided for in our constitution. And those are also captured in the agreement, framework agreement that I've talked about. However, the extent to which those the rights are captured in the agreements are also subject to different agreements. But as you know, the constitutional rights, of course, on the freedom of information and human rights are always there, and that's an issue that's been before our courts in this country. So some have been resolved, some are yet to be resolved in the courts. So I'll leave it at that.
Thanks,
you.
Christopher. Thank you very much. Delaney, do you want to come in on all this?
Yes, thank you. And yeah, I would add to that one point that, as I earlier mentioned, first of all, the countries should be particular about what is their stance or approach toward foreign investment. But at the same time, I believe that after the end of the Cold War and in this globalized society, no country says that no, we are not going to accept foreign investors. We are going to totally close our economies for foreign investment, because I think it's not realistic approach. So the most difficult task is, while you are encouraging foreign investment, while you are engaging in with these global economic activities, how to safeguard your right to regulate the public interest. So in that sense, the biggest question right now for the not only the developing countries, always the developed countries, is to what is your approach toward investment treaties? Because now there is a trends towards terminating bilateral investment treaties. Of course, we have experience from South Asia Asian countries as well, because India was adopted a very restrictive approach. They terminated most of their earlier bilateral investment treaties. They come up with new model bilateral investment treaty. The Indonesia terminated a lot of bilateral investment treaties, and South Africa terminated all their bilateral investment treaties, and they have enacted a domestic law to ensure the protection of foreign investment through their domestic legal mechanisms. So they have bring the protection of foreign investment under the domestic legal purview. So it's very difficult for the countries to actually entirely reject foreign capital and foreign investment. Now, the biggest question is, if you want to, yes, of course you want to attract foreign investment, but how its governance should be determined, whether it should be protected under international law and investment treaties, or whether they should have a domestic mechanism to provide the protection of foreign investors. So this is one of the ongoing question in my field, because most of the countries now have some skeptical approach towards signing by investment treaties. And some question is about the fundamental values of enshrined in this constitution, because most of these bilateral investment treaties provide for only the foreign investors with the right to recourse international arbitration, but this privilege or this facility or this right is not available for the domestic investors. So if you go into the fundamental basis, this is some kind of inequality between the foreign investors and the domestic investors. So, and once you accept the privately appointed arbitrators, arbitration panels, and their jurisdiction to regulate and decide about the questions which involve public interest, then there is a question as well. Because the investment arbitration tribunals are party-appointed private arbitrators. They are not tenure judges. So how they can determine the decision taken by the government elected by the people. So those issues are not just private matters. They, at the end of the day, like for example, if you're challenging a regulatory measure that was adopted by the host state to ensure the public health or environmental protection, how these party appointed private arbitrators can resolve these issues? Because at the end of the day, the public interest it's one of the matters to be discussed by these party appointed arbitrators. So that's why they are now come up with the idea about having World Investment Court, where these issues will be resolved by the judges appointed by the state. So those are always in the mainstream debate in the field of foreign investment law. And with respect to the question of model bilateral investment treaties, of course, the negotiation is always based on these model bilateral investment treaties. But I have some informal information with respect to how this negotiation taken place, because in my opinion, most of the developing countries, they don't actually negotiate. They just, the other party, the powerful party, perhaps come with their own model and they just do some adjustment and they just sign. And especially these developing countries, they don't have this negotiation capacity and they don't have very expert legal teams to analyze the text in detail and identify the legal consequence of these bilateral investment treaties. And perhaps there are a lot of experience recorded in the literature saying that most of these countries even don't know. They just sign these treaties as a matter of showing diplomatic pleasure. Once you go to a foreign state visit, you just sign a bilateral investment treaty without knowing the legal consequence of that. So that happens. I think these kind of experience have been recorded in the literature, and that most of the developing countries entered into these bilateral investment treaties without exactly knowing their legal repercussions. So that's why the model bilateral investment treaties are very important. But at the same time, when it comes to the practical scenario, it depends upon how your team can negotiate and get the maximum out of the negotiation. Unless you have a strong team to bargain and get what you want, these model bilateral investment treaties would be just a piece of paper table at the meeting. So again, I agree with your point that nowadays more and more bilateral investment treaties include human rights, labor, sustainable development, corporate social responsibility, and the home state liability to ensure that their multinational corporations will be acting in a responsible manner in domestic states. All these are included. If you look at the model bilateral investment treaties that have come up in the recent years, all these provisions are included, and And perhaps I was wondering whether these treaties are going the other extreme, because earlier bilateral investment treaties was all about protecting private interest of the foreign investors at the expense of the host state right to regulate. Now, all the provisions which ensures the host state right to regulate is ensure, then at the end of the day, there will be a little room for foreign investors to get their investment protected under the treaties. So it doesn't say that they are left in a vacuum, because if they are not find this investment treaty regime is favorable for them, they will use the contractual mechanism to get the maximum benefit for them. So I think there should be a balance between how we protect the private interest of the foreign investors, at the same time safeguard the public interest of the host state to regulate in the public interest. And at the very beginning, when the notion of balanced investment treaties is coming on, which include all these non-investment concerns, I was very happy about that. And in 2015, as a PhD candidate, I wrote an article saying that Sri Lanka also should embrace these balanced investment treaties, because I was very positive about the notion. But now today I realize that it all depends how arbitration tribunal will interpret them. Because even you can have a balanced investment treaties, but how much weight the arbitration tribunal will be given to these non-investment concern will decide the ultimate decision of these kind of arbitrations. Well, we have seen that the very recent arbitration award, those were decided on these so-called balanced investment treaties. Still, there has not much change. Still, it's still a host state has to pay compensation for some of the regulatory measures they have adopted. So it's, in a way, it's good. But at the same time, I believe that it's my personal opinion that everything at the end of the day will depend upon how the tribunals will interpret these provisions, because there is no precedent in the context of international investment treaties. So it's up to the tribunal to decide and interpret each case according to the bilateral investment treaty under which that arbitral tribunal is constituted. So it depends upon the situation. And my last point is about yes, constitutions are it's very difficult scenario in this globalized world. It's very difficult to find a balance between the private rights of the foreign investors and the public rights of the host state. But at the same time, the situation is becoming more and more complicated because of the emergence of sovereign state or the state-owned enterprises as foreign investors. Because earlier it was private investors who were investing in other countries. Now it's most of the state investors. In the rise in the context of a state capitalism, it is a state and a state entities, especially like if you look at the outward Chinese investment, most of these investments are driven by SOEs. So there's again question the private and public dichotomy between these, the link, the gap between these private and public interest, state interest is becoming more thin and blurring. So it makes the scenario more complicated. So I think in that situation, the constitution it's very difficult to find a proper balance between how, on one hand, they wanted to promote foreign investment. There's no question. At the same time, they want to ensure the protection of private investors as well, because otherwise your destination will be considered as a not favorable or hospitable investment destination. At the same time, you have to ensure the state right to regulate and the public interest while maximizing the development benefit of these foreign investors. So it's really complicated task that have been put upon these countries, especially if you want to address these issues through the constitution. It's really complicated. Thank you.
Thanks, Delini. Now we have Tom Daly wants to come in very quickly. And then we're going to go to Jonathan, has a question in chat, but Charmaine's going to try and make it possible for him to put the question directly. But Tom, why don't you come in while we're doing that.
I just wanted to say very, very quickly, I thought that was such an interesting final point by Delaney, because I think it really underscores once again that we're very good, especially as constitutional lawyers, we're very good at making public power visible. So in Ireland, for example, when we joined the EU, we added a piece to our constitution that said you can't cede any more powers to the EU unless you get a referendum of the people. There's nothing in our constitution that would prevent us setting up something like the Colombo Port City, right? We could set up something on our west coast or whatever. And I suppose that's where I'm talking here, you know, just to draw that out of my last intervention. What you've said really shows how we really need to not only talk about what we're good at on the public side and see how it can work on the private side, but also understand how the public and the private are getting mixed, as you said. So I'm just fascinated. I just wanted to come in on that.
Great, thanks, Tom. Jonathan, welcome. Jonathan's been putting a very interesting series of questions in the chat, which I'm sure many of you have been reading along with. But Jonathan, would you like to introduce yourself and then put your own questions? We can't hear you. That could be a complication. No, we still can't.
Is that any better now?
That's better. Great. Okay. Thanks.
Switched mics. Thank you. Well, this is wonderful. I mean, so I'm Jonathan Bonnicher from the University of New South Wales. I work in international investment law. I'm an academic, but I've also worked as a practitioner. I worked at the Myanmar Investment Commission for several years.
Well, now for your sins, you've met constitutional lawyers. Life will never be the same again.
Well, I mean, it's such a useful kind of change in perspective. I guess the constitutional framing, and I think this is what Tom was saying, puts into focus questions particularly about the constraint of executive power and the relationship between the legislature and the executive and judicial oversight and judicial constraints at the very simplest level. And I think one of the things that's so refreshing about that is that we in investment law tend to frame things really differently. So to pick one example, legislative restraint of executive power in relation to the making of investment contracts means something potentially very different to legislative constraint of executive power in relation to the amendment of investment contracts or the variance. And that's also true with the judicial function, because you know, judicial constraints on the making of investment contracts in some way, depending what they are, might be designed to restrain, hopefully, certain sorts of pathologies, corruption and inside dealing with foreign investors, but judicial constraints on the changing of investment contracts actually have the opposite valence. They're a form of entrenchment that serves to secure property or contract rights of the foreign investors against subject reversals. So I think straight away, the executive, judicial, legislative kind of distinction is a really, really useful dimension, but it's not enough by itself as an analytical framework. And so I guess trying to join into what I understand the project to be doing, I just wondered, and this is what people will have been seeing in the chat, whether it would be useful inductively from the discussion that we've been having from the country experts to sort of start building typologies of the different types of constitutional provisions we're seeing that relate to investment in that way and distinguishing between them. So there was a sort of long sketch in the chat that I won't read out here, but if anyone, I don't know, feels they want to explain why that's a terrible idea or how they would take that forward, I'd be interested.
Let me just respond quickly, and then I'll ask anybody else, including the panelists, if they want to come in. I mean, I think the idea of a typology is quite interesting. And the sort of typology you were developing in the chat was an interesting one. And I think we need to think about it more deeply. But one of the things that I've been thinking about along similar lines as I was listening to the participants is that sometimes constitutional provisions can have an impact, potential impact on investments of various kinds in all sorts of different ways. So Papua New Guinea, for example, has directive principles that would appear to be directly in point whether they're actually activated or not. We had a presentation yesterday from a colleague in Singapore which turns the whole thing on its head in the sense that there's a provision in the Constitution saying something like any attempt to surrender Singaporean sovereignty requires a referendum with 2/3 voting in favour. But then another provision saying, but by the way, entering into commercial arrangements that are to Singapore's benefit does not surrender sovereignty and therefore does not attract this provision. So there's just a myriad ways in which, depending on the circumstances of a country at the time it achieves independence, makes the constitution or amends the constitution, these issues might come up. So I think the typology idea is a really interesting one, and thank you for putting it on the table. We'll look at it, but I'm just wondering if it might be a very complicated matrix. What about some of the rest? Who else would like to come in on this?
May I?
Yeah, please.
And thank you, Jonathan, for your question, because it was nice to see you in person, because I have been reading your writings for a long time. Because I started my PhD readings by your taxonomy you developed on expropriation and ferment treatment. So it was very nice to see you. And I would like to comment on your question on the constitutions play a limited role relation to investment governance. I also agree with that, because the governance is basically about, they have brought this governance out of the domestic. That is the basic idea of having these international investment treaties to delocalize and depoliticize the investment governance. So I do agree with your point, but when it comes to the Sri Lanka's situation, now I'm thinking to what extent we can bring the investment governance under the purview of the domestic constitution law, because this provision is very unique, where it clearly says that if you approve a bilateral investment treaty by the 2/3 majority, it's become a domestic law in Sri Lanka. So what it means that, I think there are a lot of research should go into this provision, which has not been explored properly, as I mentioned in my presentation. But one thing is, if you have this kind of mechanism, it allows foreign investors to approach domestic courts and enforce their rights in the domestic courts. So the most interesting point here is, in this article, is the constitution prohibition that says that no laws should be enacted against or contravening these provisions, and no administrative or executive action should be taken in contravention these provisions. So this is a constitutional prohibition. So this is not a justice, as you said, this is not a ordinary law. The Constitution itself prohibits making laws, lawmaking authorities and the public authorities taking measures against the provisions that you entrench into the domestic law. I think this is something that I really wanted to study, because at this level of research, I wanted to come up with the argument that whether it provides a constitutional remedies to implement the international investment obligation. So if so, and we know that in the most of this development, most of investment dispute has been brought under the domestic courts purview, especially if you're happy with your domestic court system, and if you believe that the domestic court system can deliver the justice for the foreign investors. Most of the countries now wanted to get resolve these issues through domestic courts. So I think this provision would be a very interesting point to elaborate on your point. Of course, I do agree with your point that the constitution governance is basically about its international law, but having this kind of constitutional provision would provide us another way to think the international investment governance. Thank you.
I certainly think that if we develop a typology, we should not leave the Sri Lankan provision out. Anybody else? Christopher,
Yeah.
Alim, do you want to come in?
Yeah,
Alim.
if I may add to what Lily mentioned, thank you, Jonathan, for figuring that out. There's a lot of discussion in the chat box. For the Philippine experience, we say that the Constitution, as I mentioned in the first part of my presentation, is actually it's a guarantee, but it all lies into how the executive branch of the government would give teeth to that provision. So as you mentioned about as cited in the Article 12 of the Philippine Constitution, the ownership has been defined. So we are strict to that construction, the 60-40 sharing. And we make sure that in terms of national sovereignty, and if there are conflicting interests with investment coming in the country, we always go back to the general principle of the Constitution that we make sure, number one, is that the national interests are being protected. Now, it also came across in some of the discussion by my colleagues, the other panelists, that there is what we call play of power in the negotiating table. And that's what I mentioned earlier. I would like to stress on that implementing bodies are given that authority and power, whether to accept or to reject or to cancel registration of investments. So the executive body plays a crucial role in making sure that those constitutional guarantees are given in terms of its articulation and how power are being enjoyed for the interests of the national sovereignty, at the same time to protect the labor laws of the country and the national resources for that matter, as we've seen in the experience of Papua New Guinea and also with Sri Lanka. Thank you, Jonathan. Thank you, Cheryl.
Thanks, Alim. Christopher? Christopher, you're muted.
All right. Okay.
Yep, we can hear.
I'll just go and touch on what Jonathan has said about legislative restraint on the investment contracts. I think in our country, I think that's a very interesting question or comment, and I'd like to add to that. In our country, I talked about tax holidays and all these things, and also said that whenever the investment contract is drawn, legislative approval is always given. And for that to happen, it has to be brought to Parliament. And the challenge that we always have is that the government of the day always, as the executive government, has the power and also has the numbers on the floor. So that has always been an issue that, for instance, when you are voting against your own, the government of the day, then you have certain sort of implications against you. So these kind of things that always overrides, if you like, the standard or the normal governance and transparency principles that we always talk about. So in practice, yes, there's always challenges when we, there's always challenges available when we enter into international agreements with international investments, and the debate is also it's ongoing. Thank you. I'll leave it as that.
Okay, thank you very much, Christopher. That's great. Now, I'm just keeping an eye on the time. We've got a question in the chat from Fiona. Fiona, do you want to put it yourself?
Yeah, absolutely. Thanks, Cheryl, and thanks to the panelists as well for quite an engaging discussion. My name's Fiona. I'm a student in the master's program at Melbourne Law School and also do a bit of practice in the New Zealand context in foreign direct investment. I had two questions, quite different. The first was the kinds of processes or conditions that might exist for withdrawing approvals from investors or kicking investors out of a country where they don't comply with particular conditions. So for example, human rights violations, environmental violations, governance problems. We heard briefly about some labor and environmental requirements, but I wondered what other types might exist. The second is more in the COVID context, and it's been quite nice not to talk about COVID in many ways, but I wondered if in the jurisdictions we're discussing, there'd been a shift to a more protectionist view on investment, particularly where there were concerns about investors coming in and buying distressed assets on the cheap, or if there was an increased focus on investment as a sort of an economic lever to address sort of any economic concerns with the COVID outbreaks. So I'd be interested to hear your thoughts on those.
Thanks, Fiona. Now, we should wrap up in 5 minutes, but would any of our panelists like to quickly respond to either or both of Fiona's questions?
Sharia?
Yeah. Who's that? Alim? Yep.
Yeah, 60 seconds. Oh, thank you, Fiona. One is, as I mentioned earlier, one is we can go through the cancellation of the registration, or if the domestic governance has an issue on that, we can always go to court to challenge the vulnerability of investments that are coming in. Second, with your questions on the, what the implications on COVID-19, there is the need to legislate on other special laws, especially in the cross-border trade. We had recently an issue on the taxing authority of the government over transactions that are being done online. And this actually didn't surface before COVID, but during the COVID, all transactions are being done online. So this is one issue that we are concerned right now, especially on the cross-border trade, e-commerce law. And we are trying our best, especially for the promotion agencies and investment authorities in the Philippines, to make sure that both the national interests and the taxing authorities will do their right job, so not to pull in investment and even protection to the SMEs. Thank you.
Thank you. Christopher, any response from the Philippines to either of them?
Cheryl, you're asking me, right?
No,
Yeah.
I'm talking to Christopher. Oh, so not the Philippines, from Papua New Guinea. Apologies, I'm getting my case studies mixed up.
All right. With regard to Fiona's question on the conditions of drawing or kicking out investors if they breach the human rights and other conditions, well, yes, we do have a process that involves in getting the agreements revoked. That is possible. However, in practice, that doesn't happen. In theory, yes. In practice, there are a lot of implications in which we deal with and also, yes, deal with the issues of breach of human rights and other conditions. So though there are processes available, in practice, we don't really enforce that. However, the individuals take it on themselves to go to court to address those issues, not the government. So that's on that. On the issue of COVID, we don't have any protection on the investment, international investments, whether to restrain them, which means it's still open. And all I can say is that there's no restriction on the investment, international investments coming into the country due to COVID, business as usual.
Business as usual. Thanks very much, Christopher. Delaney, a quick response?
Yes, quick response. Yes, one is the because when it comes to how to terminate these projects, of course, as a matter of general international law, these investment projects has to operate under the authority of domestic law. So if there is any violation, of course, that can be resolved at the domestic court. At the same time, the second tier layer of investment governance is the contract, because there can be a contract between the host state and the foreign investor. If there is any violation, there can be considered under which the host state can terminate the contract, and if some terms and conditions are being violated by the foreign investor. So at all time, the question is, it would be very difficult for interference with these foreign investment projects as far as countries have undertaken the international obligation. Because if you look at international investment obligations like investment treaties, because you have seen a lot of cases where actually the government interfere with the protection of public interest, and there can be a lot of misconduct in the part of foreign investors, but at the same time, they use this tool of ISDS mechanism to challenge the host state, the governmental actions, and they can get the compensation. So that is the biggest issue. Of course, you have the sovereignty to interfere with the problem, but the problem is if it has an economic impact which was approved by or recognized by the arbitration tribunal. The problem is always you can interfere, but if something goes wrong, you have to pay the compensation. So that is the biggest issue in investment treaties. And COVID situation and the protection is the one last my last observation, my recent observation is, I think Jonathan will agree with me, because a lot of countries are now coming up with national security reviews, because national security reviews are not only just the military concerns and the security concerns, it's all about the economic security, energy security as well. Because if you look at the EU, is one of the most open market for the foreign investors. Even they have come up with national security mechanism in the very recent 2019 and 2020 in order to control the strategic, as you said, like acquisition of this strategic industries like technology by the Chinese investors. So there is some sort of a protectionist approach is going on, and the regulatory stance of these countries becoming on the increase. But at the same time, we have to say that now instead of investment protection, now the new aspect of these investment treaties is the market access and the liberalization of investments. So on one hand, the protection mechanism is going on. At the same time, if we look at the most recent investment agreement concluded in principle by the China and EU, the one chapter is dedicated entirely for the market access and the investment liberalization. So we have to, it's remain to be seen how we're going to balance between the protectionist approach and the investment liberalization in the future. So thank you very much.
Thanks, Delini. Watch this space. Well, we've come to an end of an absolutely fascinating session. I just want to make two quick remarks by way of conclusion. You've all listened to this unbelievably rich discussion. One is that Arturo yesterday raised the question of the need for domestic, constitutional and international lawyers to talk occasionally. And we could not have had a better illustration of how important that is and how this discussion actually can't be pursued unless those two bodies of knowledge and those two different perspectives are brought together. And we've been extremely fortunate in being able to do that in this session. And my second comment is to say, well, we may not have solved very much, but one thing we have, I think, made clear, which is that any country embarking on a constitution building exercise, particularly de novo, but even renewing a constitution, one of the things it should think about is its foreign investment approach, whether it's strong or weak and whatever it does about it. But it's obviously a relevant consideration to take into account whatever the solution may be. So very many thanks to our three wonderful presenters here today. You've done a fabulous job. We're very grateful to you, and we'll be back in touch for more help in due course. So thank you, everyone. Now, I'm going to hand over now to the chair of the fourth session, Amanda Katz-Burrell.